In case I get shot, I want you to carry on.
We will.
Shot?
Oh, we'll go down there on the end now if they're
Sit
shooting
next to
involved.
me. I'll let the deputy sit next to me. Sit down, Will.
Oh, is this high profile me?
Yes, high profile. Welcome everyone to House Banks and Banking. We'll call this meeting to order. And Chairman Hill, would you open our meeting up with a word of prayer? Would you do that for me, please? What's your number?
16 or 15.
15. Thank you.
Oh, dear Lord, just thank you so much for all the bounty that you've brought us and what we see forth on this wonderful spring day, and bring us the guidance and wisdom to hear the testimony that we're to be presented with soon, and that we can ponder it in the moral direction that you have given us. We thank you for all the folks that are here, that are healthy. We pray for those that are not healthy, and we thank you very much for the protection of those that are abroad that give us this freedom to meet here today. In thy name we pray. Amen.
Thank you, Chairman. Let me mention, I regret that we canceled our meeting yesterday. I know there was people who traveled. I appreciate you coming back. It was unavoidable. If it's any consolation, we passed a large tax decrease for the citizens of Georgia. So that was what held us up. But thank you for coming back. In addition to welcoming you, I'm going to take a point of personal privilege and welcome three special guests via the internet. My wife, Amy, who is homeschooling, my two sons, Andrew and Jonathan. They're taking a break from their studies and watching these proceedings, so I'll do my best not to do anything that they would be ashamed of. We call it Crazy Academy at home, but welcome to the meeting, Amy and boys. This is our posture today. The presenter of the bill, the author of the bill, and his supporters have an hour. He uses it at his discretion, however he wants to allocate that. Afterwards, in the time remaining, it will be equally allocated to those speaking in support of Senate Bill 448. Then afterwards, there will be an hour for those opponents of Senate Bill 448. The questions from the committee the only questioning will be the committee questioning the author of the bill or his designee while he is here. I know we have an emotional subject. I know there's been expressed some passionate feelings, both for and against, but I'm confident that we're going to keep good order. No matter what's said, we don't want any comments audible, everything done in order, and we're going to treat everyone with respect and civility. And speaking of civility, we want to welcome the paragon of civility, the chairman of the the chairman of the Senate Rules Committee, Senator Don Balfour, to present a substitute to Senate Bill 448. He'll be discussing LC 390256S in your folder. So, Senator, are you ready?
Mr. Chairman,
Then proceed.
this hearing on this bill today, I'll make some opening comments, and I'll let my trusted assistant go through the bill in more detail, and we'll both answer some of your questions. Georgia has one of the highest foreclosures and closing of banks in our nation. And some of the reasons we're introducing this bill is to take care of those type situations. I've heard from community bankers for a number of years about this type problem. You know, 3 or 4 years ago, we had a problem with big banks. They were too big to fail. You remember that? How many of them have we made smaller? Those those banks that were too big to fail, we've made them bigger. Now, explain that to me. So when next time we have a problem with the big banks that are too big to fail and now they're bigger, guess who's going to bail them out again? This bill gets into a specific situation, and I'll go through one example, and then we'll go through the substitute and some of the corrections. And I think when it came through the Senate, it was maybe more of a shotgun approach, and this substitute would make it more of a rifle effect and take care of some of the concerns that people had when it came through the Senate unanimously a couple weeks ago. But we have a situation where an organization, a company can go in and buy discounted notes. Nothing wrong with that. That's business. That's capitalism. So they buy a discounted note. They buy a note for 20 cents on the dollar. Now, first off, that company doesn't have to do that, do they? No one required them to buy that note for 20 cents on the dollar. But they thought they could buy it for 20 cents on the dollar and hopefully sell it for 30 cents on the dollar and make some money. And that's fine, too. Nothing wrong with that either. But they buy the note for 20 cents on the dollar, and then they sue the person whose note it was for the 80 cents. Now, the original bank has every right to sue that person for the 80 cents because they're the ones that, in essence, would have defaulted on the loan. The new buyer of that note, who bought it for 20 cents on the dollar, I have a hard time understanding how he can sue this guy for 80 cents on the dollar when he bought it for whatever he bought it for, when no one required him to buy it. This is a bill that would try to correct some of these problems of some of these predators out there that are making huge profits that hurt community bankers and small businesses around this state, and try to make it a situation where we're starting to go after. What we go after first is not the person whose loan it was, but we go after the property first before that. So I'm going to turn it over to go over specifically the amendment to the bill, because to be honest with you, what you've been hearing from what came through the Senate is a lot bigger than what we have in here, and there are a number of restrictions, and we've kind of made it quite a bit tighter for you to look at. So we're looking at a smaller situation than where we are today. Why don't you just introduce yourself?
Thank you, Chairman Balfour. My name is Scott Leventhal. I'm a native Atlantan, been in the real estate development business for the last 17 years, primarily focused on developing around Metro Atlanta and throughout the state. As Chairman Balfour indicated, the committee has been offered a substitute to limit the effects of SB 448. And rather than going through and reading line by line the committee substitute, I'd like to just touch on the highlights of what the bill now says and does. First and foremost, we have heard a lot of discussion from opposition, from support, from people talking that the retroactive application of the bill may be damaging. We think that it is very important for the General Assembly to be able to respond to the issues which Georgia citizens are facing day in and day out as a result of the failures Chairman Balfour has discussed and the windfall opportunities that a lot of investors have been obtaining. One thing that we have recognized to be an issue is the bill as originally drafted provided for modifying judgments which had already been entered into on debt obligations which have been transferred. The committee substitute bill has excluded judgments, and that is no longer a factor. The next issue which we have heard from people is that the bill has unintended consequences.
Pardon me, would you mind repeating that last part again? I missed that about the judgments. Just
Chairman,
please.
Yes, Chairman Morris. The bill as originally drafted said that this article shall apply to all debt obligations which are in existence and all judgments which have been entered into on debt obligations that have been transferred to a successor creditor. In a successor creditor, we have defined, and I'm going to talk in a little bit further detail, is not a bank. It is a non-regulated entity that has come in and acquired an interest in a contract. Not the contract, not changing the contract, but an interest in it. We have also heard the concern of the unintended consequences of automobile loans, credit card loans, student loans, all which would be affected by this bill. The committee substitute also specifically excludes any of those types of loans. So we have now limited the scope and capacity. Further, we have added a proposed amendment to Title 44 under 44.14.161 to be inserted as a subsection 1 that deals with an issue for all borrowers in the state of Georgia, whether it be residential borrowers, commercial borrowers, and it deals with the current loophole in Georgia's confirmation process. If I might digress for just a moment, about 75 years ago, the state of Georgia enacted a confirmation proceeding because at that time, following the Great Depression, lenders would foreclose collateral that secures a loan. They would bid it in for below market value. The next day, they would turn around and they would sell that collateral for a real market value and then go and pursue a full deficiency judgment against the guarantor of that loan. Well, when we enacted the confirmation statute, still keeping Georgia as probably the most creditor-friendly state in the country, we said that creditors have a right to gain access to collateral with 4 weeks' notice, and then they go to the courthouse steps and they foreclose. What they then have to do if they want to pursue a deficiency judgment against any guarantor of that loan is go to any superior court, report the foreclosure sale, and prove to the court that they actually paid fair market value. Well, today there is a loophole, and what creditors are doing, whether it be successor creditors or original creditors, they are obtaining a judgment on a guarantee first, not worrying about the collateral, not seeking to foreclose the collateral, getting a full judgment, and after they've obtained a judgment, they will then go and foreclose the collateral that secures the loan, thereby completely circumventing the process and the requirement to go report the sale and prove that the guarantor received the true market value credit for the collateral. And the last amendment does address that issue for all borrowers in general.
Senator, do you have anything to add before we go into the question time? Are there any questions from the committee? Representative Nix.
Yes. Thank you, Mr. Chairman. Senator Balfour, I have a question. When you made your opening comments, you said this would be there to help the banks. Can you tell me why the first notice I got was from my community banks calling and saying you must oppose this bill?
Happy to. Representative Nix, I have to apologize. I had an epidural in the neck this morning, so my turning ability is a little limited. I think that and I recognize that there's going to be a differing opinion, and you're going to hear from opposition shortly that will tell you a different set of facts and circumstances. But the reality is Georgia is the #1 state in the country for bank seizures and failures. The federal regulators have targeted Georgia. We've had more failures than anywhere else, and the estimates predict that that failure rate is going to continue. Part of the rationale and the reasoning may be because the regulators have eyed Georgia as a place that they can quickly go in and gain control of assets, and then they can actually enter into joint venture partnerships, and they can receive a percentage of the profits that come from those loans as opposed to just being an insurer of the bank's deposits. It's a fairly perverse relationship when you consider it. And under the pressure and the scrutiny from the federal regulators, a lot of community banks have been locked up. They've been seized. They don't have an ability to work with their local customer, the Georgia citizen, and instead they're being primed for failure. We believe that SB 448 would be a way that the federal regulators could see that in the hands of community banks, as opposed to in the hands of successor creditors, there is an opportunity for that bank to actually have a better recovery on the loan, not risk a loss to the shareholder capital and the people in the community that have made an investment, and give an incentive to allow that community bank to be able to work with its local borrower. And there are a lot of people in this room that you're going to hear from today that are small builders, small developers, small business people. And all of them depend upon the lifeblood of their business, and that is the community banks. And in large part, the doors are shut for these people to go in and borrow from the big 5 banks that are out there. And as Chairman Balfour indicated earlier, it's quickly evaporating. The pool of opportunity they obtain credit is quickly evaporating. And we all do know, right, wrong, or indifferent, credit is the backbone of our economy.
May I follow up? I would just like to kind of go on record to say that I've heard from many, many banks, and I have yet to have a bank ask me to support this bill. So obviously what you're telling me is the banks are just not smart enough to understand what's going on. Is that what you're saying?
No.
Help me a little bit, please.
You will hear from banks today that will say the opposite. Now, are you saying that they're not smart enough either? I would tell you there's maybe a difference of opinion between the banks. I'm not saying banks aren't smart. I tell you what, the Rialtos of this world who can buy loans for 20 cents on the dollar, sell them for 40 cents, make 100% profit, and then sue you for the 80 cents, you explain to me that math. You explain to me that math. They're making 100% profit on their money, and then they're suing you for the 80 cents. How could they sue you for more than 60 cents? How could they possibly do that? Can you explain that? That mathematically doesn't make any sense at all. These guys are making 100% profit or more based on monies that they're getting from Washington anyhow. And when these community banks go out of business, do you think that money's staying in Georgia? That money's not staying in Georgia. That money's moving to the big banks outside this state. They're going to suck all the money out of Georgia before it's all said and done. The math on this just doesn't make sense. If I have a loan, if I have a $100,000 loan to a bank and I default on it, that bank has every right to sue me. Every right to sue me. This bill would do absolutely nothing with that whatsoever. But someone else comes in and buys the loan because they're going to make a profit on it, which is fine. They want to make 100% profit, that's fine. But how can they make 100% profit and sue me for $80,000 too? How can they do that? I mean, no one can tell me that's right. Your community banks can't tell you that's right. Ask them how they work that one out, because they're not doing it. It's not the community banks that are doing that deal. It's the folks in D.C. that are doing that deal.
Which number was that? 20. Representative Smith.
Oh, thank you. Obviously, this is quite a passionate issue here. Just have a couple of questions with respect to the policy initiatives that we're looking at. Is this bill retroactive? Would this bill be retroactive?
We'll have someone else talk about the retroactivity issue in a few minutes. If you will, someone who's more legal on that issue.
Okay. Would this bill not eliminate the ability of creditors to sell their claims to third-party traders, and as such pretty much eliminate this entire process in the state of Georgia? Would this occur?
We also specifically have testimony from an expert in the industry that will tell you that when a person acquires debt today of an existing debt obligation, they're not giving any credit value to the guarantee. They're looking at the underlying collateral and the underlying collateral only. And nothing in the bill, I would like to be very clear about that because I have heard from folks, nothing in this bill is a restriction or a prevention from allowing a bank to sell its debt.
Last question. Under federal and state law, would this be unconstitutional?
We'll have someone else that will. You want a legal person to answer that, not two green eye shades, but that we'll have a legal people answer that question.
Thank you.
Well, and I hope, and Senator, remember now that we're not other witnesses. Once you leave the well, so to speak, will not be getting direct questions from the members. If you want to swap out Mr. Leventhal for somebody and let them kind of come back into, that's entirely up to you.
When they speak, they will speak to those specific issues, because those are all very good questions and very valid concerns that need to be addressed.
Okay, good. Is that it, Representative Smith? Okay. Representative Peake.
Thank you, Mr. Chairman. Chairman Balfour. Let me just make sure at least for this body, make sure there are two amendments. We have LC 390256S, and then there are two amendments, AM 39021 and then AM 390019. Are those the two amendments? Are you saying what's addressed?
The 0019, the last number you said is basically this committee substitute.
Okay, so that's not.
You could take that one and just throw it away, because that's
okay,
what we did was we came up with a committee substitute versus an amendment to the bill.
Okay,
That's the only difference.
So the substitute bill we have, the only change to the substitute bill we have is AM 390021. Is that correct?
The committee substitute you ought to be working through is 0256S.
And there are no amendments to that.
Well, we could. There's a possibility of looking at AM 390021.
Okay, all right. Just want to make sure we're working on.
But the other one is
already
really
in the substitute bill. Got it.
563.
Got it. Okay. Just want to make sure we're all clear on that. Can you point to me in the bill? I'm a borrower, so I understand the position. I also sign personal guarantees with banks, so I understand the contractual obligation. You hit on something that is at the heart of the matter on this. Can you point to me in the bill, so we'll make sure everybody understands where it is, that fixes the loophole of a bank being able to go after getting a judgment, being able to still go after the value of the collateral as well as the personal guarantee? Can you just make sure we specifically know where that is in the bill that addresses that loophole?
Representative Peake, that begins at line 62, section 2.
And you believe this language is sufficient to do that?
Again, I'm not a lawyer, but my opinion is that this language for all loans, in successor creditors or not, says that in the proceeding to obtain a judgment on a guarantee or an obligation, that the court is supposed to take into consideration the true market value of the collateral that secures the loan.
Okay, good. Thank you. That's a great. I think that's a huge need and issue that needs to be addressed. I'm glad we're addressing it in this bill. So,
Senator or Mr. Leventhal, let me ask you to direct you to lines 43 through 45 on page 2. Give me I see regardless of when such debt obligation was incurred. Explain that not being retroactive. Do you want to do that or have that addressed?
Mr. Chairman, I prefer not to give an opinion on the legal implications of it.
We have a lawyer that will come up in a minute and go into that section. And you won't have to ask him questions. He, in his conversation, will go into that issue as well as the other ones mentioned a minute earlier. I'd rather have someone of legal significance answer that than myself.
Okay. Yes, sir. Representative Flood.
Thank you, Mr. Chairman. Senator and Mr. Lowenthal, a couple of questions along the same lines. Back to the court being able to determine the market value. Would that market value not be artificially depressed by the value of that collateral being depressed?
Yes, sir, it would.
Okay. Now, you mentioned that this excludes credit card loans, student loans, So what kinds of loans are included?
It would include real estate loans. It would include business loans. For example, a $200,000 operating line of credit for Mr. Jones that wants to operate a telephone repair company in Woodstock, Georgia.
There was a reference earlier to this being a bill that helps small banks and small businesses, but it really doesn't limit itself to small businesses. A large developer or any other entity who would have borrowed money could still benefit from the passage of this bill, correct?
I think legally, Representative, that is an accurate statement. I think practically it is not. And an example that I would give is in a lot of instances when big business borrows, and I can pick on my industry because my industry is obviously a topic of discussion, but if a publicly traded real estate investment trust wants to build a new apartment complex somewhere around the airport, their decision to go out and borrow from a bank is going to be based upon their balance sheet, them as a borrower, as a public entity. And what they often do is only borrow in their name, and no personal guarantees are ever provided. In the instance where we see personal guarantees come into play is generally for the small business borrower, someone who does not have a company balance sheet that may be sufficient, has assets, has other means, but does not have full sufficiency, so they'll look to the principals behind the business to guarantee the debt. Well, in a practical application, I don't think that this is a direct benefit to big business.
Okay. One last question, Mr. With regard to that personal guarantor, right? So I know that there have been some changes to the bill. I just want to make sure that I grasp. The senator used an example of a borrower borrowing a dollar and now the loan being sold for 20 cents on the dollar and being able to come after him for the 80 cents. Going forward, would he be now relieved of the 80 cent obligation? And if there's a successor creditor?
This bill may be helpful just to take a quick step back and talk about what a loan is and what a loan obligation is. You have a debt and you have a borrower. In a lot of instances, that is secured by collateral. You also then, in instances, have a personal guarantee. And what we are talking about is trying to protect the personal guarantee, which is truly the Georgia citizen that needs help and assistance. If this bill were to pass, the rights of the creditor, the successor creditor, are not limited whatsoever to go against the collateral. They're not limited whatsoever to go against the borrower, but they are limited to go against the guarantor for the amount they paid to buy the debt, plus interest.
Isn't the guarantor and the borrower the same?
No.
In the description that you just described? Because you said earlier that if it was a large corporation, they wouldn't need a personal guarantee.
No, we have a lot of businesses that operate in Georgia, mom and pop businesses, small entities, family businesses, development companies, various proprietors. You can turn on the radio nowadays and you can hear an advertisement from, I forget O.J. Simpson's lawyer's name, but he's offering for $600 in corporation. Well, generally as a practice, businesses operate through a business, LLC, joint venture, partnership of some sort. The personal guarantee comes from the individual or some other entity. And a guarantee is an agreement to pay someone else's debt. It is not the primary debt of the guarantor. It's the primary debt of the person that borrowed. What we are saying is that the person that has agreed to guarantee that debt is the one that stands to benefit, not the borrower.
Are you saying that, and I have a small business, I have a S corporation, that there is a third party guarantor that doesn't have an interest in the business?
They may or may not have an interest in the business. There are lots of instances where people do not have an interest in a business but provide guarantees for others. Family members sometimes will provide a guarantee to help a relative on some basis obtain credit so they can start a business.
Okay, thank you.
Chairman Houston.
Let me try to get this straight about you talking about guaranteeing a loan and personal guaranteeing. Is that sort of like co-signing a loan? Are you saying that if you co-sign a loan that the third person would not be responsible for that loan if I co-signed a loan?
You're getting into some technical terms, Representative. generally co-signing a loan would be as a guarantor or as a co-borrower.
So a co-signing a loan is different than personal guaranteeing a loan for another person?
It's a general term that would have specific application. And I think that a lot of people would say if you co-signed it, you've guaranteed it. But technically, I don't believe that would be accurate. Again, what we're talking about is a distinction.
Well,
and if we could look at it again, I asked Jay Knight earlier, who's going to testify, if I could use his company as an example in this matter. But Knight Family Homes wants to go out and wants to build a house. Well, they want to go to a bank and they borrow the money to build the bank, and that's that entity, Knight Family Homes. And oftentimes, the bank will require that Jay comes in and he personally guarantees that loan. What we are talking about affecting is Jay's responsibility, not Knight Family Homes' responsibility.
But isn't it true that one reason the bank would give that loan is because Jay had some money that he was for, that is that one of the reasons they let him have the money, because of his credit rating, and Knight had no credit rating, so they would expect Jay to pay it if Knight company couldn't pay it.
I absolutely agree. I think that the loan was given based upon the credit that Jay brought to the transaction. Wholeheartedly agree. And I don't think that's what we're talking about here today. What we are talking about is what the rights are of someone who comes in and buys it from the bank that gave Jay's loan. And I draw that distinction for a specific purpose. I heard yesterday a lot of discussion, I heard on Monday a lot of discussion when the Commissioner of Banks was here about what subjective rights does a lender have. Can they sell a loan? Can the acquirer come in and they can just say, you're in default, I'm going to accelerate. The loan may have been performing, and then they automatically have a right. That's oftentimes called being deemed insecure. It's also a very, very common default that is contained in community banks' loan documents. And when a small business person goes to their community bank and they say, I need to borrow $100,000 because I have a venture, and I'm going to stand behind it. Well, part of the reason that bank decided to make that loan was not just because of the credit strength, but it was because of the relationship. And that relationship is the heart of this issue.
But don't you think sometimes our community banks, they have a customer that's current, that's paying all the time, and they would like to keep that loan in the bank, but FDIC really won't let them keep it. They'll make them do away with the loan. And it's not really the bank's fault, because it would help the bank stay alive if they could keep the good loans.
Absolutely.
I can't argue with that.
Thank you.
Yeah, and I think that's an extension of what Chairman Houston is saying. In banking, the loan is the asset, and it has a value. And if the guarantee does not go to the successor creditor, the concern that has been expressed to me is the loan is less valuable. It may be less liquid, it may be less valuable, and that's so the guarantee has value past the original debt obligation. Would you like to respond to that, or either?
Mr. Chairman, I would like another person to come up that is an expert in that industry to be able to talk to you about that.
I have another question, but just for we'll do this question, and then there should be approximately 30 minutes, Mr. Chairman, to however you want to. That's where we are. Who's 22? Oh, Chairman Knight, right here.
Thank you, Mr. Chairman. Senator Balfour, you had mentioned earlier on when you started off that this necessarily wasn't a bank issue, but the feds, the FDIC was coming in, taking these loans, and there was a partnership or a co-ownership of the loans that were being sold to these third parties.
It's and someone else is going to have to get into the details on that more than I, but we started out with banks that were too big to fail, and these community banks are starting to go away. I mean, we talk about, well, we don't want this. Well, what is the answer? the community banks, we're losing community banks right and left in the state of Georgia. We're number one in the nation for bank closures. And these new banks that are buying these loans aren't necessarily Georgia banks. These are these are going to Washington, and they're getting TARP money and everything else to help pay for this stuff. It's basically sucking a lot of Georgia financing dry. We only have 30 minutes, so.
Thank you, Mr. Chairman. Chairman Balfour, on line 69, I think it is, 70, am I to understand that the value of the collateral, the value of the loan can be collected, and then the value of the collateral can also be collected in addition to the collateral, the value of the loan? Is that what you're trying to say there, or what you're saying there?
Representative, what line 69 is intended to provide for is if a loan is secured by any type of collateral, when the judgment is obtained by the court has to take into consideration the true market value of the collateral, which is very similar to our current confirmation proceeding. And then before awarding a judgment, they are going to give the obligor a credit to the amount of that collateral.
Or are you saying that's not occurring now on these third-party successors?
It is absolutely not occurring in a lot of instances because creditors have, whether they are original creditors or successor creditors, have found a current loophole in Georgia that allows them to circumvent the confirmation proceedings. And what they do is they first obtain a judgment, then they foreclose on the collateral afterwards in a separate proceeding. And because they have already gotten the judgment, they do not have a requirement to go and prove that they actually paid fair market value for the collateral. And then the obligors under that judgment do not receive any credit for it. It's a loophole.
Who would receive title ultimately to the collateral?
That would be, if it goes forward under a foreclosure proceeding, Georgia law would say that it is sold to the highest bidder at the courthouse steps.
And who would receive that value?
If the foreclosure were to occur subsequent to obtaining the judgment, and let's just say it's 12 months down the road, and the creditor sells it for more than the true market value that the court determined, then the increased benefit would also further go to reduce the judgment. If it sells for less than the true market value, nothing happens.
Mr. Chairman.
Mr. Chairman, if with time as it is, we have a number of speakers we want to speak. I'd rather not cut myself off, but with a limit of an hour to each side, I would like to let some other folks come up here and talk about some of these questions about retroactivity, constitutionality, and things of that sort. We have at least one community banker who's going to speak, and a few others, and obviously we only have, 20, 25 minutes left. So
That's fine. Al. Very quick.
And I just want to get to the heart of the matter here, Chairman Balfour, make sure that this isn't going to preclude banks from selling troubled loans to a third party outside the state company like a Rialto or other. It doesn't preclude them from doing that. And it doesn't preclude the banks who sell these loans from still going after the balance on the guarantee that they have a contract with the borrower on. Is that correct?
If they have not sold the loan.
Okay, if they've not sold the loan, they can still go. So what it will force the banks to do, in effect, is either deal with the borrower, work with him, who are most of the time local folks in our state who employ people and have jobs and put a lot of people to work. Is that correct?
right.
Yes, sir.
Okay.
Absolutely.
Just want to make sure that's.
Okay, the way we'll handle it is Mr. Leventhal, kind of your guy who's saying this is, whoever comes up, because I want to give you the right to say who comes
Absolutely.
for the remainder of the time.
Thank you very much, Mr. Chairman.
Okay.
Appreciate your time.
You want to get?
Mr. Chairman, I'd like to ask for Richard Gaudet to come on up and try and address some of the questions that were asked about banks, workouts, loan sales, some of those particular issues, and then try and address some other.
Why don't you just stay right there?
Yes, sir.
Please. Thank
Yes. So long as next session we can try and take up an air conditioning reform.
Yeah, well, that's true. Well, the state's in dire straits. We're saving taxpayer money. Introduce yourself and tell who you represent and your interest in Senate Bill 448.
My name is Richard Goday. I'm a principal with a local firm by the name of Glass-Ratner Capital and Advisory. I have roughly 30 years of banking experience, 7 years of experience as a financial advisor working in turnaround matters. In my career, I have acted as seller, purchaser, or advisor on the sale of over $5 billion in debt. Excuse me. My clients typically include banks. I prepared and drafted as a contractor for the FDIC the structured sale process that you referenced earlier. I have advised banks in the acquisition of other banks in loss share, and I've represented approximately 200 real estate developers in the Southeast in negotiation of roughly $20 billion of debt over the past 5 years. In my opinion, I think somebody asked the question earlier about, does this impact the value of a sale of a distressed debt? I think it will possibly impact it, but not in the way you expect. By example, I have here the 10Q for a company that is one of the structured sale purchasers that were referenced earlier. This company, during 2011, their fiscal year ended in November, collected or resolved through foreclosure $545 million of debt, and through foreclosure $74 million through principal collections. During that period, they collected $5,270,000 on deficiencies. So the reality is they didn't pay and didn't collect. Less than 1% of their money came from deficiencies. Sorry, the pollen's getting me. When you purchase a debt, the price you pay is based on the expected cash flows that you're going to receive on that debt. So if I look at a loan and I look at the collateral and I consider the time it will take me to secure that collateral and sell it, and then I discount that back at my target return, and that's the purchase price I pay. In my experience, I sold, first debt sale I did was in 1987. In my experience, you don't pay for guarantors. If you collect it, great, but generally, in 30 years of collecting bad debt, that last dollar is very expensive to collect, and going after guarantors is very costly. So I don't think it impacts the calculation of a price in the purchase of a debt. What it will potentially impact, I will concede, is that influencing the borrower to do what you want, to cooperate in a foreclosure, to assist in a transition of the collateral, the guarantee plays some value in that. In this capacity, you still have some guarantor liability subject to the value of the debt. So if the person impacts the collateral negatively, he could potentially fall below that threshold. I'll give you an example. This same company, during 2011, I mentioned foreclosed on $545 million in real estate. They marked up on sale. Their accounting policy allows them to, when they foreclose something, they write it up to the market value. They marked up during 2011 $85 million. So by foreclosing, merely foreclosing, they achieved roughly a 16% return on their purchase price. So now keep in mind they collected something less than 1% on deficiency. So does it impact their overall business model? Minimally. Finally, I'll say, as I mentioned, the purchase process is fairly straightforward. It's what am I going to collect, how long does it take, and how much profit do I want? It works well, it's very efficient. Where it does not work well is where you have outside influences. The biggest offenders, and in my opinion, the primary reason that you even consider this bill is because of loss share banks and structured sales. Structured sales, and I'm somewhat ashamed to say I participated in the development of this. There is a cap on the internal rate of return that a buyer can receive under a structured sale. If their return exceeds a certain level, then their percentage ownership drops from 40% to 30%. Well, as you know, internal rate of return is a factor of dollars as well as time. So if your dollars are capped, what you do to maximize to stay right at that maximum level of IRR is you extend the time. What extends time? Litigation. So if you sue people, you're going to have an extra year to play around with the thing. This company ran $130 million in overhead last year. And I don't know, I don't have the information to do the calculation, but I would bet you that much more than $5 million of that expense went towards pursuit of recovery solely for the purpose of delaying the recovery. Second point, they get paid on the unpaid balance of the pool a servicing fee by their partner, the government, of I think in this case it's 1/2 of 1%. So settling it quickly, my return is capped. If I settle quickly, I'm capped. If I settle quickly, my servicing fee stops. If you owe me $5 million and I take $100,000 today to settlement, then that's $5,000 a year that I'm not going to get. I'm sorry, $25,000 a year at half of 1 point. So there's, when you have the intervention of outside influences, it takes an otherwise very efficient market and sets it on its head. Loss share, and I know this bill as drafted will not impact a lot of the loss share banks. Okay, but that's another place where we see these issues employed, where you have outside influences impacting how people would otherwise do their jobs.
Thank you, Richard.
Any questions?
Well, we're not doing questions for the witnesses, but thank you.
Thank you.
For appearing.
Mr. Chairman, if I may ask what the time is.
15 minutes.
Mr. Chairman, I would like to make sure that both Larry Thompson, who is another borrower, can have some stories come up and talk at this moment. And I also want to be sure to reserve time because I know there's a lot of legal questions for Jimmy Franklin, who's come in from Statesboro.
You got 15 minutes, however you want to allocate it.
Thank you, Mr. Chairman, members of the committee. My name is Larry Thompson. I'm a real estate developer and builder in Cobb County. I started my business, which is a family business. My wife worked with me from day one. We started our business in 1969 when I got out of the military. I've also been in the banking business. I was one of the original founders of a bank up in Cobb County called Cobb American Bank, which became Riverside Bank, which became Bank of North Georgia through acquisitions and mergers. So I know a little bit about both ends of the spectrum. I sat as a director on the bank for many years and chaired the loan committee at one time. So I can address some of the things, although I'm not an attorney. I can address some of the things, and I'll do it by example as I go through, and I'll be as brief as I can. One question was, and I will address that now, I think, and I don't mean this in a derogatory term, but I think many of the community bankers are unwittingly becoming the architects of their own destruction. And I'll tell you why I believe that. The reason, first of all, analyze why does a bank have to sell assets? Why do they have to do that to begin with? Because their capital base has eroded. Why has the capital base eroded? Because the market value of their underlying collateral in real estate loans has diminished. They're not in the same 20 to 80% or 80% loan to value that they were. The market value of the collateral has diminished. Why has the market value of the collateral diminished? It's because of the monetary policies of the Federal Deposit Insurance Corporation. Period. End of sentence. And I'll show you examples as I go through this. Now then, if banks will sit down, we've got what I call the law of mental inertia going here. There's so much information back and forth, a lot of it erroneous on both sides. But if particularly community banks will sit down and analyze what this bill's really going to do, I think most would step behind it, except for the big, larger banks. And it's actually profitable for them to see the smaller community banks closed. Why? They get their assets, they get their depositors, and they get all their business. So it makes it's good business for them to see these small banks closed. But to me, it's a tragedy because the small community bank is the lifeblood of a small businessman. Some of the community banks that I've dealt through the years since 1969, my computer system was tied into the bank's computer system, so they knew at the end of the day exactly where I stood financially, or where my corporation stood financially. So I think if they'll really analyze this, they'll start to be part of supporting this bill. And I'll use some specific examples as we go through. We touched on the issue of these predator creditors. I'm going to use that term instead of calling names. Basically, the way that is structured, the FDIC went out and has entered into partnerships with certain private industries throughout the nation. One of those industries is a private home builder. Now, bear in mind, this home builder owns Rialto Capital. One of the partners of Rialto Capital is the FDIC. Now, these people go into one of my banks demanding that they raise capital. Do you have a question, ma'am? Okay, all right. Oh my goodness. All right, I'm going to skip through a lot of it. At any rate, when one of my competitors can partner up with the FDIC loans that competitor interest-free money, non-recourse, for 5 years to buy troubled assets. FDIC goes into one of my banks, sticks a pistol to their head and say, you've got to raise capital, we're going to shut your bank down. So they start selling off notes to raise capital. One of these notes doesn't go directly to them, but it goes to an intermediary, and my business competitor winds up literally stealing my projects. Now that madness has got to stop. It has literally got to stop. And that's not the only. There's example after example after example. You will find that many of these loans are not in default when these loans are sold. They're sold because the bank has to raise capital, because their asset values have deteriorated. And some of my bankers here that bank me through all of this stuff are here, and I think they'll agree with everything I'm saying. But I'm running out of time, I know. I want to give one quick example so you can really understand it. There's a builder up in Cobb built a house for $3 million. Had a $1.5 million construction loan on it, had a little over $1 million of his money in the house. His construction loan lender was forced to sell off loans to raise capital. They sold off his loan, sold it for $600,000. People that bought the loan called him under a call provision. I know there's a big issue about contracts. FDIC can arbitrarily throw the contract in the garbage, and they do it consistently. So, you know, contract take two people. In this case, FDIC ignores it, wants us to do, stand up to our end of the bargain while they throw their end of the bargain into the garbage can. That madness has got to stop. But anyhow, this one example I'm talking about, this young lad, they went into federal court seeking a summary judgment. They called his loan under a call provision. They just said, we feel that we're insecure, so we're calling the loan. They have the ability to do that. He was not in default. Go to the federal court system, get a summary judgment. Then they come back. Now, you got a summary judgment for $1.5 million. Then they come back and start the foreclosure process on his property. They bid it in because nobody else is bidding. They bid that house in for $100,000. Now they've got $700,000 into a $3 million house. They resurrect the guy's sale, sell it for $3 million. Now they've just made $2.3 million, plus they got a $1.5 million judgment against this guy. Now who gets that money? The FDIC gets 60% of it, and the predator gets 40% of it. That's why I say bankers are unwittingly becoming the architects of their own destruction, because it's profitable for the bank, for FDIC to shut down banks, particularly in Georgia, because our laws allow them to do it. Okay, I'm out of time.
Thank you, Mr. Thompson. I'm sure if anybody wants to hear Mr. Thompson continue, he'll be happy, I bet, to talk to you on a private basis. Mr. Left, I know Mr. Jimmy Franklin from Statesboro. The first vote I cast as 18-year-old was Franklin for Congress in 1982.
I didn't get enough.
Yeah, well, somebody must have canceled my vote out, but we did the best we could do. Mr. Franklin, proceed with your remarks.
Well, thank you. I am Jimmy Franklin. I'm a practicing attorney in Statesboro. I have been there since 1966. I'm a founding partner of 11 lawyer law firm, and while I'm not a debtor creditor lawyer, I'm primarily a litigator. I have debtor creditor lawyers in my firm, and we have been asked to look at this proposed legislation, and specifically in a relatively narrow area, to determine what our opinion may be as to any constitutional issues that may be evidenced on the face of the proposed legislation. We have done that. I have also consulted with former Chief Justice of the Supreme Court of Georgia, Lear Sears, and her firm has reviewed it. And I've also consulted with my daughter, who is a lawyer, and we have looked at it both from the cases in the state of Georgia and nationally. And I know we're close to being out of time. The conclusion that I've reached is I don't believe in the present form of the proposed statute, that there are serious constitutional issues. Obviously, I can't tell you there won't be litigation over anything that you pass. We can't guarantee that. I can't tell you absolutely what the appellate courts or the trial courts in this state may do. But based on our observation and our conclusions, we do feel like that it will pass constitutional measure.
I'm going to take chairman's privilege and ask a specific question of this witness, because I think everybody here is concerned about retroactivity.
Yes, sir.
And I want to address specifically lines 43 through 45 in the sub. And when I read when such debt obligation was incurred, when means a period of time. Now, does that mean? Tell me why that is not retroactive.
Yes, Mr. Chairman, I would concur that that would be a message from this body, and if it was signed into law, that it would apply retroactively.
So we do have an element. We may not have the same retroactive features that we had in the original Senate Bill 448, but we do have elements of retroactivity in the sub.
And I would point out that courts in Georgia recognize the ability of the legislature to designate that a bill should be applied retroactively. If it is silent as to retroactivity, whether it should be applied retroactive, then the courts have to look at it and they have rules of construction where they have to decide whether this is merely a remedy or an evidentiary change or something that is not of substance. You know, we get into pretty deep legal theory and analysis there. But they also recognize that if the legislature specifically says it shall be applied retroactively, the courts generally acknowledge that unless there's some other constitutional problem with the legislation. Hopefully but yet to answer your question, yes, with this language. Now, we do have...
You're saying it's retroactive,
yes,
but not unconstitutional.
Not necessarily.
Okay.
There are exceptions under Georgia law and under the Georgia line of cases, and I could cite those to you, but in the interest of time, obviously I will not. But there are cases where just because it's retroactive, that does not necessarily make it a bill or a piece of legislation or a law unconstitutional.
Okay. Yeah. All right. Well, that's a good distinction for the committee to know. There's a difference between retroactivity, and according to you, and unconstitutionality. And I'm certainly not the one to spar and debate with you on legalities. It's your expertise. But now, doesn't the Constitution specifically not allow the General Assembly to go in and change the terms of a contract, a legal contract between two individuals?
Well, that can be done as a general rule. I would agree with that. But there are exceptions to that rule, as there are to most rules.
Okay.
If the substance of the legislation merely is to address a remedy or to alter a remedy of some situation that the other legislation addresses in substance, then the courts recognize that may be applied retroactively. I read this morning a United States Supreme Court case where very similar to the issues we have before us, establishing value and crediting value. This was a case that was decided in 1941 where they held that the state of New York could do this and it could be done retroactively. So it's not an issue that has not been addressed. But yes, I don't think that just on the face of it, that this is a violation of the Constitution, either of the state of Georgia or the United States. We have what we call the contract clause in the Constitution, but the United States Supreme Court specifically addressed the contract clause in the New York case decided in 1941.
This may be an unfair question, but Mr. Thompson just gave a scenario of a contract, a note that an individual made with a bank and successor creditor. You heard the story, and you've heard the story. And you would say, are you saying that in that situation and in that contract, and you're not reading the document, I understand, you're saying that particular type of contract could be entered into retroactively, as he described it, by the legislature, and it be constitutional? Because we're mostly talking about the notes and the contracts between a lender and a real estate borrower. It could be others.
I believe that under the case law in Georgia and the other case law, that the courts very well might. I can't guarantee that, but I think they might consider this as a remedial action by the legislature that falls within that group of cases that could be applied retroactively. As a general rule, they do not like retroactive, but they do also look at the intent of the legislature and what is written into the legislation. The vast majority of cases where the courts of this state are required to say whether this applies retroactively or prospectively are cases where the statute itself is silent, and the courts have to make the determination based on whatever the evidence may be and so forth. Of course, we're not talking about a modification of the original contract now. Also, not the contract between the original lender and the borrower and the original guarantor. We're there would be no modification in that. What we're saying, what the legislation says, is that once that is assigned, that the right to recover from with a action or lawsuit against the guarantor is limited to what he has in it, plus interest. That's all that the original maker or the bank was allowed to do. Certainly he couldn't do it. And what we understand and what's been given to this committee is we're having companies, individual companies are going out there and basically double dipping. They're suing the guarantor for the full amount of the loan or the balance on the loan, and then retaining the collateral and selling it so they could reap many times the value that they invested in the deal when the bank couldn't have done
that. One last point, and then we're out of time. If in the note the borrower has agreed, that all rights in the current note goes to any successor creditor when you sign the note, then our actions, although we're not changing the wording of a contract, our actions could be construed as not allowing the contract to be fulfilled, which amounts to the same thing. How would you quickly respond to that, because we're out of time?
Well, I do think, and I can't say absolutely, Mr. Chairman, but I think that the courts could very well look at this as being addressing a remedy to a situation rather than because, and that's what has been upheld again in the New York Supreme Court case. They did the very same thing, a bill that was passed after the fact, and they said that the holder of that note at that time, actually that was the original borrower, but they even said that could be changed by the legislature in order to correct what obviously appeared to be an inequity. And there's a lot of
Okay.
rationale about the Depression and what was happening and so forth.
I think I see where you're going.
Okay.
Thank you.
Thank you, Mr. Chairman.
Very briefly, Mr. Leventhal, you wrap up. 15 seconds.
Mr. Chairman, there's just a couple points I wanted to touch on, which I think will be discussed. One, this is very similar to a law recently passed in Nevada, which is an update to Nevada's anti-deficiency laws. We have heard a lot of opposition say this is unconstitutional in Nevada. It's before the Nevada Supreme Court, and it's soon going to be heard. What everyone seems to neglect to say is it's already been decided by 3 separate courts and 3 separate judges in Nevada and been upheld as being constitutional. It is on its way to the Nevada Supreme Court, but that doesn't mean it's unconstitutional, and there hasn't been a law since. The last point that I just would like to touch on, which is a direct response to some of the comments that I heard at the committee on Monday, the rules are written in pencil for the people we're dealing with. The people in the state of Georgia that need your help, we are dealing with a group whose rules are written in pencil. The FDIC can seize a bank and immediately, under 12 U.S.C. 1821E, they repudiate the contract. If they still said that they were going to advance monies, they no longer have to fund $1. And then they begin a proceeding to collect on the obligation, meanwhile leaving that borrower with half-built, half-owned real estate. We need, as Mr. Franklin pointed out, because we believe this is a remedy effect, the citizens of Georgia need your help to deal with this issue.
Thank you, Mr.
Thank you very
Leventhal.
much.
Thank you, Mr. Franklin.
Just one, we have our severance clause in here. If the court should hold that this was retroactive, and
The remaining parts of the
not
bill would
applied,
be
it could, the
okay.
balance of the legislation could stand.
Thank you for your additions.
Thank you.
Okay. Yeah, now the other side gets an hour and 5 minutes because we went over. Yes.
For clarification, if lines 43, 44, and 45 were struck, that would eliminate the retroactive part of this bill.
I don't
Is
know
that
if there's
correct?
another retroactive part in it.
Okay.
That was the one I was discussing.
right.
But again, as he pointed out, the severability part of it, if that part would be found unconstitutional, the remaining part of the bill would still be in
Okay.
effect.
Can I ask one more quick question?
Yes.
It was raised, and just want to see if you can clarify this for the committee. It was raised that these third-party groups that are coming in, predator creditors, is the way he described them, or Rialto, whatever,
Yes.
they are partially owned by the FDIC. Can you clarify that
Again,
for the committee?
The clarification, but let me. This is my understanding. Lenore Homes, Rialto is a subsidiary of some type related to Lenore Homes. It was my understanding that the Federal Deposit Insurance Corporation injected capital into this organization for the purpose of buying distressed assets that they knew would be coming or that they felt would be coming. Now, that's a whole other issue about, but
Seems like a
that's my
significant-
understanding roughly of that
Seems
relationship.
like a pretty significant conflict
Yes.
of interest, if you ask me. But,
Well, as we discussed in the previous hearing, there's agreement on that. Let's go ahead to the witnesses for the opposition, and we'll get back to, if we can, to everybody else. Mr. Blanchard, Kessel, Stelling, Mr. Kessel Stelling, and Jim Edwards. You are first on the list. Whoever would like to, of your group, just come and please have a seat and identify yourself for the committee, and welcome to the committee. We're going to start out with how much time? If you gentlemen will, let's 10 minutes. 10 minutes for you fellows. Identify yourselves for the committee, whoever's going to be testifying. And again, welcome. Thank you for coming.
Thank you, Mr. Chairman. My name's Kessel Stelling. I've been in the community banking business in the state of Georgia since 1974, when as a summer employee of the Georgia Railroad Bank in Augusta, I worked my way through the University of Georgia as a banker. So I feel like I have a little bit of background in this subject matter today. Will be followed by my colleague Jim Edwards and then Jerry Blanchard. I want to thank all the members of this committee and you especially for hearing us out today to hear us talk about Senate Bill 448. Now, I know there's been a substitute proposed, but I didn't have the benefit of that, so I'll have to speak to what I assumed on the way up today and would be happy to follow up with any follow-up testimony. Mr. Chairman, I think this bill would be terrible for community banking and for business in the state of Georgia. I think it's no accident that you have the Community Bankers Association, the Georgia Bankers Association, bankers large and small, united in opposition to this bill. Today I serve as chairman and CEO of Synovus Financial Corporation. We operate in 75 communities throughout the state of Georgia. We have 3,000 employees. We operate in this state of Georgia. We operate under different brand names. We operate as Columbus Bank and Trust in Columbus, Athens First in Athens, the Bank of North Georgia in Canton, the Coastal Bank in Brunswick, Citizens Bank in Rome, Commercial and First State Bank in Thomasville and Valdosta, and in LaGrange and in Warner Robins and in communities throughout this state. It was stated last week by many that this bill did not apply to banks or that we were exempt, or even an op-ed column in Friday's paper that this bill would be healthy for the community banking system in Georgia and in the recovery. In my humble opinion, Mr. Chairman, nothing could be further from the truth. The argument that it didn't apply to banks or that it doesn't apply to banks was correct only in that it did not apply to a bank as a purchaser of a loan, but in reality banks are sellers of loan, and this bill would completely shut down the sale of loans by banks. It would not just chill the sale of loans, it would kill the sale of notes. Mr. Chairman, this bill applies to and hurts banks in Georgia because it applies to any person that buys a loan from a bank. Our banks have long relied on existing law that states that notes can be sold, transferred, and assigned with all rights of collection passing to the purchaser. That is negotiated on the front end. It is agreed to by the bank, by the borrower, and by the guarantor. No investor is going to take the time to do due diligence, buy a loan, and incur the risk and expense of that if he is ultimately limited in recovery to what he paid. There is zero upside, and the downside would be the entire amount of the note. And Mr. Chairman, I just want to state again, the notes I'm referring to were negotiated in good faith by the bank, by the borrower, by the guarantor, in most cases well represented by counsel, and the only obligation we asked were that that borrower repay money that was validly loaned to, received by, and owed by the borrower or guarantor plus interest. The sale of notes has been an effective tool for our industry for many, many years, both in good times and in bad times. It has been a source of liquidity for banks, and we routinely pledge loans to the Federal Home Loan Bank as a source of liquidity, and I saw a letter in the last day or so from the Federal Home Loan Bank questioning their ability to fund banks' liquidity based on what this bill might do to the notes on our balance sheet. But today, we're not talking as much about performing loans, we're talking about non-performing loans. I want to reiterate what one of the committee said. We don't sell loans for no reason. In fact, most in our industry are competing every day to make good loans to Georgians. We typically sell loans that are classified or non-performing either to comply with internal or regulatory targets or regulatory demands, or just sometimes where it's just more advantageous to us to sell the note, avoid the cost of litigation, put the money back to work for our customers, for our shareholders, and all of Georgia. Simply put, the sale of notes allows us just to return to the business of lending. And Mr. Chairman, banks, I hear the extreme story of selling loans for pennies on the dollar. We never want to take losses by selling a loan. We typically don't sell a loan when the borrower and the guarantor are working to resolve the credit in good faith. We sell the note only when selling it at a loss is better than holding the loan as a non-earning asset. This bill, as I understand it, is retroactive to loans that have already been made and on our books today, where the language of the contract clearly states otherwise. It's retroactive to loans that have already been sold, and Georgia law has long been clear as it relates to the sanctity of contracts. Mr. Chairman, this bill would turn long-standing law and business practice upside down. Investors want certainty, business people want certainty, bankers and borrowers want certainty, and this bill provides for none of that. I believe these issues will be tied up in litigation for many years, a stalling tactic that will certainly prove beneficial by many of the proponents of the bill, and meanwhile the economic recovery of the state of Georgia will be stalled and damaged. Current loans on our books today, negotiated in good faith, will be questioned as to their collectability, their marketability, and their enforceability, and they'll be questioned by accountants, by regulators, by our investors, by the Federal Home Loan Bank, and by others. Capital will flee this state, and a bank's ability and willingness to lend going forward will be compromised. Reliance on a guarantor and the sworn financial statements they provide to the bank at the outset of the agreement, and which have long been relied on by banks, those statements will be questioned, they'll be compromised, or they'll just be ignored, and the result's going to be tighter lending restrictions and much higher equity requirements for a bank to finance a project. We'll lend solely on the ability and the value of the collateral securing the loan. Our historical reliance on the two other C's of credit, character and capacity to lend, are going to be thrown by the wayside. Those personal guarantees that were so critical to the formation of businesses, the creation of jobs, and the very backbone of our financial system will now be meaningless once a note is sold. And Mr. Chair, I'm not for 1 minute going to question the character or even the capacity to repay of some of the proponents of this bill. As a matter of fact, many of them, including Mr. Thompson, are friends of mine, and I hate that we're here today. This great recession has claimed many victims and has created pain for most of us in this room, for banks, for bankers, for their board members, for their depositors, their shareholders, and their communities. And certainly it's created pain for borrowers from all walks of life, the small business owners, doctors, lawyers, legislators, home builders, developers, consumers from all walks of life. The pain has been immeasurable and good people have been hurt, but this bill doesn't solve for that, and it actually hurts even more. This bill benefits only a few, a group that in all cases had an obligation to pay, signed a valid contract to pay, and in some cases today still have the ability to pay and just have chosen not to. Now, it's with no great pride that I claim any degree of experience and expertise in dealing with problem loans, but the problems of our company have been well publicized, and there are some days I feel like I've earned a master's degree in problem loan management. But I want to say to this committee, in the height of our company's problems, our non-performing assets never hit 8% of our total loans. Said another way, 92% of our borrowers worked through their obligations, repaid their debts, and are in good standing today at our worst time. Of the non-performing group, the large majority of those worked with us. In some cases we settled, in some cases they signed the deficiency, but in most cases the loss was shared by both bank, borrower, and guarantor. There was pain on both sides, and we moved on. This bill benefits a very small group that falls into neither one of those categories, either performing or working in good faith. It benefits a group who typically were not able to work that out with the bank, and the bank chose to sell the note. And Mr. Chairman, I understand that some of the targets of the bill include a regulatory agency, a purchaser of notes. It involves complaints about unfair collection and wrongful foreclosure, and those problems can be and should be solved in another venue, a more thoughtful and deliberative opportunity where we can look at those laws, and I will pledge my company to work with any authors of such bills to address any concerns there. But this bill in its current form goes so far beyond that. It further cripples our industry, and this industry that has so long been a part of the success in Georgia of home builders, of developers, of businesses large and small. So I thank you for your time today. I would urge this committee to vote no on a bill that destroys the time-honored principle of honoring and enforcing valid debts. And I'd like to turn to my friend and colleague Jim Edwards for further testimony.
Mr. Stelling, we have 5 minutes left for however you all want to, and if we have a little bit of time, I'll take a chairman's privilege to ask one question. What I want to do is synthesize some of the questions that we've had concerning why individuals don't buy loans, and that type of thing. So if you'll leave me just a little bit of time, I think the committee will be interested in hearing on a larger bank level some real life why it works like this and how. Okay? Thank you.
Mr. Chairman,
Proceed, yeah.
I'm Jim Edwards. I'm CEO of United Bank, which is a community bank based in Zebulon, Georgia, about 50 miles south of here. I appreciate the opportunity to speak to all of you today. We've heard from a lot of family businesses that spoke earlier today. I'm proud to say I'm a third generation of my family to be involved with leading the bank. This is clearly a bad bill for our industry, and it was presented really as something that would help banks, but I think it's pretty clear that with the strong support of all the bankers here today, that it's a common consensus, I think, among bankers that this is very bad policy for banks. The first reason this bill is bad for community banks is that it limits the ability for us to sell problem loans, and you heard Kessel talk some about that. But when you get right down to it at the end of the day, banks have regulatory orders. You heard Chairman State Banking Commissioner Braswell speak a couple of days ago that over half the banks in the state are under some form of regulatory order, and those orders require banks to reduce their problem assets. This is a way that can be done to be complied with, and I know there's a lot of frustration. I've heard here from some of the earlier folks about the FDIC. That may be valid, but this is not the way to solve that issue, because it's going to continue to hurt community banks, and it's going to, in my opinion, will cause more community banks to fail if this bill moves forward. One of the main reasons is that in addition to needing to sell problem assets that it would limit, it hurts banks' capital ratios, because I would ask all of you, when you're home and talking to your constituents, ask your bankers, how easy is it to sell new stock in your community bank today? They'll tell you it's extremely, extremely hard, okay? And in all these orders from our regulators, not only do you have to reduce problem assets, but you've got to increase your capital ratio. There's two basic ways to do that. One way is to sell stock. Well, that's not really an option today. The other way is to shrink your bank. And the way you do that is by selling assets typically and removing problem loans through these sales. And what you're doing, if we move forward on this, is you're taking away a very important way for community banks to do that today. I also think...
Do you mind if I interrupt you and ask you a question?
Absolutely.
Okay. Let's say scenario. We passed this bill. Opponents have voiced to myself and the committee that the loans will be illiquid. The Rialtos and others would say this is just too much trouble, it's not profitable, where the proponents have said and have made strong arguments that then the FDIC, we're going to have property values increase because we're not dumping it onto the market, and it's going to help the banks. To do that, the FDIC would have to cooperate on some level. I mean, your experience with FDIC, they walk in and say, your concentrations are too high here, or your capital ratio based on whatever losses you might have had over a certain period of time, and you have to shrink the bank the way you described. I mean, do you think, knowing them and your experience with them as a banker, do you think they are going to recognize, you're going to tell them, well, we don't have a way to sell these loans? If that's true, if it does become illiquid, and you don't have a way to sell the loans, what do you think the FDIC is going to do at that point?
In my opinion, the FDIC has got a lot of talented people that work there. They are a federal agency, and I don't think they're going to care a whole lot about what our problems are. They want us to fix the situation here. They're our regulator, and they've got a job to do. And we can sit here and debate all day whether, how that ought to be done. But at the end of the day, I don't think this state, a change in this is going to, the FDIC is going to say, well, you know what, we just can't push them so hard now because they can't sell. They've lost one of these options here. I don't think that holds any water.
Mr. Blanchard or Mr. Stelling, you want to comment on?
Follow up is one who does have a lot of experience with the FDIC and the reduction of classified assets and note sales. And I can't speak for them. The commissioner of the state banking department is here today. But the FDIC, when they ask a bank or tell a bank to reduce their levels of classified assets, they are not prescriptive. They don't tell you how, nor do they care how. Those banks that are able to do it survive, and those that don't are forced into mergers or closures. And I think, again, I can't speak for the FDIC, but they never say sell notes or do this. Is you will reduce classified assets. And those banks that lose that primary vehicle of selling assets will be forced with other options that are a lot less pleasant than we're talking about today.
Mr. Blanchard, do you concur with that?
Yeah, I do. I'm Jerry Blanchard. I'm a partner with the Financial Institutions Group of the Brian Cave Law Firm here in Atlanta, and we represent community banks across the Southeast. The FDIC is based on formulas, and when they come in and talk with a bank, they give the bank certain targets to bring the bank capital up. They don't necessarily care how the bank does it, whether it raises capital by shareholders buying in or by selling assets. By reducing the value of assets, it hurts the bank's ability to comply with those FDIC orders. The FDIC will not give them a grace period or additional grace period just because of passage of the statute, in my opinion.
The committee has been interested in why, and I've heard many of the people who have been subjected to the difficulties, troubles that you have when your loan is sold to a successor creditor. And the question is always, if you're going to sell it, if you're going to sell the loan for 40 cents on the dollar, if that's what you have to do, if the borrower offers you 50 cents on the dollar, why does it go to a successor creditor? Why would they not be offered that? Under what circumstances? Could probably one of you two probably would.
We can both take a stab at that, but the bank is interested in its least loss, its greatest value. By the time a bank sells a note, in general, you can hear extreme cases probably on both sides.
Mm-hmm.
But when a bank sells a note via bid, auction, it is because those efforts to work with the borrower and guarantor, or the time allowed us by regulators, has been exhausted. We would absolutely rather get, and without violating privacy laws, which we can't, we could furnish lots of testimony about settlements with borrowers, settlements with guarantors who signed deficiency notes, and that was deemed to be a much better and fairer exit for both.
Let's focus on the time allowed by the regulators, because I think we've all had to work with creditors at some point in our lives. And the FDIC does not allow, there are restrictions on some of these instruments being sold back to the person, back to the original debtor.
Yeah, Mr. Chairman, let me address that. You have two situations. You have one where the bank is under a consent order with the FDIC and is attempting to sell assets, and they may do that on a case-by-case basis, one at a time, or they may sell it in a pool.
That's generally where these folks get in trouble, is when a bank is under consent order, and a lot of us are.
But they're attempting to sell it at for the highest value that they can. There's no incentive for the bank to sell it for the least value.
Right.
The second category of loans are the ones when a bank fails and the FDIC has taken over the loans and is now managing them or has sold them to an outside investor. The difference between the bank and the outside investor is that the bank is under certain accounting and regulatory compliance rules to maintain its capital at a certain point. So it has to move. It has to have action. An outside investor has much longer time period to recover that loan. And so they can obtain a judgment. They can wait years, whereas a bank can't wait years because it has to write the asset down. So there's a fundamental difference between how a bank looks at a credit and an outside investor looks at a credit.
And that's, I think that's, I hope everybody's listening to that part. I mean, there's a difference. And we keep always coming back to the FDIC. And the large amount of our banks that are troubled and under consent orders, and where most of this trouble is arising from.
And the main point again is I don't feel this bill is a way to fix that. I understand the frustration, And we could probably, you know, bankers obviously can get frustrated at regulators in the middle of a recession here, but this is not a way to fix that. And I think I speak for a lot of bankers in the state when I say that.
Well, I'm afraid our time is up for this particular segment, but thank you for that, for the perspective there. We want to make sure we get every level we can. Thank you, Mr. Blanchard, Mr. Stelling, and Mr. Edwards. Thank you. Mr. Bridges and Mr. Oliver. And let me say, while they're coming up, we're obviously not going to get to everybody on either side. I don't know when the session's going to be over. I don't know what other hearings opportunities we're going to have. But we want to get to everybody. We want to hear from everybody. Mr. Bridges, Mr. Oliver, or tell everybody who you are and introduce yourself to the committee.
Okay, I'm Steve Bridges. I represent the Community Bankers Association of Georgia and our over 220 member community banks across the state. And I have with me here today Dan Oliver. He's one of our member bankers. Dan's the president and CEO of Vinings Bank here in Metro Atlanta, and he's a career banker of over 30 years in this, in the banking business. Been in both large and small banks. I'll let him tell you a little bit more about his background. I'm going to have a few comments to make first, and then I'm going to turn it over to him because he's certainly the expert on the banking issues. But I want to thank you, Mr. Chairman, and the committee for the opportunity to testify before you here today in opposition to this legislation. I probably am going to change gears just a little bit here because from everything I've heard, most of the testimony and discussion on Monday during the hearing with Commissioner Braswell and so far today has primarily focused on the sale of distressed assets or problem assets. And that's a very important discussion to have. I think it's very important. Commissioner on Monday indicated that the ability for a bank to sell distressed loans is a very important tool for them to have to help them work through this serious downturn that we're in. And I certainly agree with that. Something we probably have not done as much of as what some of our larger counterparts have, but it's a tool we'd like in our toolbox. And it's also an important discussion to have because of, and it's already been mentioned a number of times, because of all the pain that has resulted from the economic downturn that we've gone through, and that's pain for both community banks and for some of our customers. And some of those are developers and builders that have testified today. But I want to urge you to get beyond the emotion of this issue that we all feel regarding all the circumstances that have been created, and look at what this bill really does, and look at how devastating it would be to our community banks in this state and the recovery of our economy. We fundamentally disagree with the primary purpose of this bill. We don't think it's good public policy of the General Assembly to, in essence, forgive debt on contracts that were made in good faith. The bill, in our opinion, I know you've heard testimony otherwise, but it seems to be retroactive and in regard to contracts that people have relied upon in good faith. So I don't agree with the intended purpose of the bill, but I want to go, again, beyond that and talk about what I hope, are some unintended consequences of this legislation that, if it passes, could disrupt what I'm going to call the normal day-to-day operations of our community banks in this state. And I've got just a couple of examples that I'm going to try to keep it short, that I want you to understand these couple of examples would create some harm in terms of the way that community banks are able to operate. Folks, community banks all over the state make SBA loans to support the small businesses in their community where they operate, to support local business development. We've got some community banks that are preferred lenders under the SBA loan program, and they have a real niche in this program. And then we've got some other bankers that are not preferred lenders, but they use third-party vendors that help them put together the packages, the loan packages, and they still make loans to their small businesses in those communities. 100% and these are some facts that I've learned in checking into the SBA loan program in the last few days. 100% of all SBA guaranteed loans that are made are personally guaranteed. That is a requirement of the SBA. Now, that's one of the elements that has to be present in this bill in order for the limited recovery to apply. Almost always, the community banks sell the guaranteed portions of those SBA loans. Sometimes they sell even the unguaranteed portion, but almost always they sell the guaranteed portions. For one thing, it generates some good income, and it also, maybe even more importantly, generates additional liquidity back to that bank so that they can make more loans to more businesses in their community. Now, those loans are sold to both banks and non-banks. I could not get any good statistics on the percentage of them on a statewide basis that are sold to non-banks, but I'm going to use one bank as an example who is a preferred SBA lender. They gave me permission to use their name here today. They couldn't be here today, but they are a preferred lender in the SBA loan program. They told me that 75% of the loans, SBA loans that they make, are sold to non-banks. So that means, again, another element that would apply under this bill. Many of those loans are sold to brokerage firms, and then they're either resold to individual investors, or sometimes they're bundled together and they are sold as a security with a piece of them. And over the life of that SBA loan, these loans or securities could be sold multiple times to multiple investors. My point is that these transactions meet the critical elements under this bill to fall into the limited recovery ability on the guarantor. Now, I want to make this very clear, Mr. Chairman and members of the committee, I cannot definitively tell you here today that this bill would shut down the SBA lending market in this state. However, what I can tell you, I've talked to capital markets people, I've talked to lenders that are actively involved in this program, and quite honestly, no one can figure out exactly how this bill would impact it at this point in time, but they have a high level of concern, I would tell you that. So bottom line is everybody's still trying to figure out what the impact is. So I think you can see the potential devastating effects there. For some of you from rural areas, there are some banks, there are other programs, some of you involved in SBA lending, your banks are in those areas, but there's also other government guaranteed lending programs, some of them through the USDA, where they work very similarly to the SBA. There's a guaranteed portion, they sell it off. And those banks, those loans are, generally speaking, agriculture-related loans. So, at any rate, this is basically a statewide issue from that standpoint of this potential problem with this. The other thing that I want to mention just very briefly before I turn it over to Dan is something that I believe Mr. Stelling already alluded to, but this is a very important day-to-day business practice, normal business practice, that this would potentially impact. Community banks need to borrow money from time to time to operate. They may need liquidity for temporary periods of time. Those borrowings in today's environment have to be secured. They're not going to lend money to us unless they're secured. For one type of borrowing that I think Mr. Stelling alluded to is advances from the Federal Home Loan Bank of Atlanta. One type of collateral that they will take for those types of advances is small business loans, most of which are going to have personal guarantees. And I have also seen the letter that Mr. Stelling referred to where that they question their ability to continue to give credit at that level toward collateral for us to borrow. So that means we're going to be able to borrow less money on our collateral that we have to pledge. Therefore, we won't have the liquidity. Therefore, we won't be able to make loans to small businesses in the community. Now, I'm going to stop right there, but I hope these are unintended consequences to the normal activities, day-to-day activities of a community bank. I hope this bill wasn't intended to deal with that. But I think you can see that that would be pretty devastating to our community banks and to the communities they operate in.
Thank you, Steve. My name's Dan Oliver. I'm CEO of Vinings Bank in Smyrna. And I have been in banking 40 years, 26 years of that with community banks, 14 years with a large bank. I am also chair-elect of the Community Bankers Association of Georgia. But, Mr. Chairman and members of the committee, I'd like to make it clear that I am not speaking on behalf of the CBA today. These are strictly my remarks, as well as those related to my experience in the industry. Much has been covered well, I think, particularly by Kessel in his earlier comments. He sort of covered the whole gambit pretty thoroughly, but there's a couple of points I would like to reiterate and affirm, if you will. One is I do believe there would be a distinct chilling effect on the market for selling assets. In this case, I know we're talking about credits or loans. But the worry there is that anything for those of us in the free market that impacts supply and demand, or just the free market capitalism that we all enjoy, is always a concern. And elements of this bill, I think, distinctly do that. There certainly have been mistakes made on everybody's part, as there always is. All of us, whether we work for a federal agency, the state, a private bank, or businessmen, citizens in the community, unfortunately are human beings. And we're saddled with our own set of weaknesses and flaws and whatnot. And certainly there errors have been made. And over time, I think those will be corrected. But this structural change in distinctly changing the character of an asset, which is already on the books, with a set of conditions, terms, and covenants that are very clear and distinct, is extraordinarily troublesome. As a buyer, it would be hard to evaluate in every case an existing circumstance versus a new one, because if you have a new opportunity to lend money and you're conscious of a bill such as this, you can make amends and judge and change the nature of the arrangement such that you better protect yourself in light of what may occur. Unfortunately, with this bill, there are literally billions of dollars, in this case in the hands of small banks, that couldn't be. You heard one other banker testify about 2 ways to grow capital. And at the root of this problem from the bank's perspective, that is the issue, is preserving and or protecting or growing capital. He mentioned a couple of ways. One, to sell stock, the other one to shrink the size of the bank. Well, there is a third way, and I am sitting here humbly grateful that we enjoy that third way, which is to make money. We are a profitable bank. Our capital grows each month. And yet, even for us, where I'm not faced with selling our relationships because we work very hard to get those, we bank almost entirely small businessmen. We bank in whole or in part somewhere around 200 companies in Atlanta. Each one of those companies is really a person, and they do in fact have an organizational name that would be incorporated or limited liability company or partnership or whatever, but that's really not what they are to us. They're people. And it is crucially important that the guarantee, which lies at the heart of this, I would like the committee to understand that often the guarantee is taken for reasons other than monetary reasons. The guarantor may or may not have sufficient capital to totally retire the debt. But what he does have, somebody must not like what I'm saying. What he does, what the guarantor does have is a unique expertise, the talent, and the ability to make a loan perform, something that I can assure you I know I certainly cannot, and I don't know of any other banker that can make it perform. So the objective is always to keep that individual engaged in the process. And yes, often or not often, but on rare occasions, you do have to make a compromise settlement. That's just part of it, and that's the risk of business. But absent that guarantee having some teeth to that individual, the guy who knows everything about the genesis of that, whether it's a project or a business, the guy that knows how to correct deficiencies in it and cure those deficiencies so that every party loses less money than they would have, is absolutely crucial. And that's one part I think that is very troublesome and worrisome to us all. And I know you've heard a lot. I guess choose not to repeat much of what you've heard. I thank you for your time, and I'll be happy to answer any questions.
I guess the other thing the committee has kind of talked about, and your opinions based on your experience in the industry, is how is this going to play out? I mean, this wasn't an issue until 2008 or so. All these things started happening. Is it going to be a function of the banks that are still troubled before they finally are either part of a loss share agreement or they're closed? I mean, or are we looking at a function of real estate values increasing? I mean, if it's not this bill, then what is it?
What makes it get better?
Yeah, what's going to make this stop? What's going to make the people that have testified and been in my office talking about the things that have happened to them? I mean, what do we do if it's not this?
Sorry. I can only give you my perspective on it, and Steve probably has a better and more broad perspective than I do. Okay. From my perspective, it'll take some combination of a number of things. There are still a number of banks that unfortunately are so wounded that there's probably no capacity in the marketplace for them to recover. But the reason there's no capacity is not a lack of capital. There's plenty of capital. All of the capital out there now, for the most part, is extremely fearful. It is afraid of risk-taking. It is afraid of the actions of certain individuals in certain positions of authority that may or may not take aggressive maneuvers towards that entity. And then you also have the general populace and the general business community that shares most of those attributes. Most of my clients are reluctant, even though they're financially very capable, to take any new projects on. They're very pragmatic and cautious about risking things they have not already risked. So it'll take some combinations of, I guess, a shrinkage of financial institutions, a little recovery in the value of assets, but also some risk-taking on the part of businessmen to make it better.
So in conclusion, I guess you're saying the stories that we've been hearing, I mean, there are other people teed up to go through the same process. I mean, the people that have the loans in these banks that may fail, I mean,
It would only be my guess, but yes, sir, I would guess there are a number of those.
That's too bad. Well, Mr. Oliver, thank you. Mr. Bridges,
yes, sir.
Thank you for your time. Mr. Kopczak, welcome to the committee, sir. Identify yourself and.
Thank you, Mr. Chairman, and members of the committee. My name is Jason Kopczak. I'm actually a managing director and a partner at Cantor Fitzgerald in New York. I'm not sure if you guys recognize our firm. We, lost 650 people in 9/11, and today we're 5,000. We're considered a broker to institutions. My group specifically handles advisory services to community banks. So our job is typically to come in and advise community banks on the different disposition / modification and workout strategies for their distressed assets. So typically community banks will call us up, ask us to come in, review a portfolio of distressed assets that they want to figure out what are their options to manage and best recover their value. So typically would come in, institution will provide us a pool of distressed assets. We will show them what the maximum value on recovery for workouts, for restructuring and working out with the client, as well as bringing in outside capital partners to recapitalize the asset with the debtor, as well as pricing for disposition purposes. This way we provide them information, they come back, they make the decision how they want to manage the asset. They'll typically engage us to follow through on one of those strategies. So that's what we do in my group. Over the course of the last 3 years, we've advised on over $20 billion in troubled assets. It's clearly obviously part of the credit crisis. The majority of our clients are community banks. So to kind of give you a little background, we advise clients all throughout the country. Florida, Georgia. Georgia happens to be a predominant part of our business. There's obviously a lot of banks here who have troubled assets, but step back a second here. I just want to clarify. There's been approximately 78 banks that have failed. 68 of them were acquired by local Georgia banks. Okay, number one. Number two, when you look at the market, one of the top disposition strategies, it seems like most, I apologize here, I believe most banks, their strategy is to modify and restructure, okay? Disposition is typically the last route. So what banks do is they typically identify core clients, try to restructure and turn the loan from a bad, subperforming, non-performing loan into a accruing loan. Okay, that's their target. Typically, as mentioned earlier, loans that our borrowers are unable to restructure, maybe they're litigious, maybe they're uncooperative. Banks at that point, due to regulatory pressure, they're under severe regulatory pressure, they will look to disposing of these assets. They'll come to us, they'll ask us to price these assets and what it would go in a sale, so they make that decision. If ultimately investors are capped at the basis they put into these assets, investors will flee the market in Georgia. Banks will be saddled with more distressed assets, more non-performing assets that they'll have to have longer timelines to work out. Ultimately, it makes them more uncompetitive. So these banks now will not have one of their main exit strategies, which is disposition of non-performing assets. They will have to hold on to these assets for a much longer time frame. And banks in other states will have a much quicker and speedier avenue to clean up their balance sheets. So when regulators are pressuring Georgia banks to clean up their balance sheets, their competitors in other states will have a quicker and easier solution to clean up their balance sheets, which ultimately puts the banks in Georgia at a much more non-competitive situation. And then ultimately what that does is the banks clean up their balance sheet, they can come back in, out-of-state banks will come back into Georgia and they'll lend to the better clients. And you'll see that customers will start going to out-of-state banks because they'll have cleaner, much more aggressive lending opportunities. So that's typically how I see this bill playing out. One more note, if you look at the residential side, 93% of the loans originated at this point go to Fannie, Freddie, or HUD, which is FHA. All three agencies require a personal guarantee. If the personal guarantee is materially altered, those three agencies will pull out. You'll have 93% of the market for single-family residential mortgages altered, and that affects single-family borrowers. So, yeah, I think at this point, the bill in its current state is definitely will have a material problem to current lending standards. So,
in the course of your advising the community banks, I mean, how much of your interaction is with the FDIC and those that are under consent orders or?
Well, typically what we get is we get calls from the community banks when they're getting regulatory pressure. Mm-hmm. So we'll get a call when a regulator comes in and says, you need to reduce your exposure to non-performing assets. They'll call us up. They'll ask us to provide them on a loan-by-loan basis what is the different strategies available to them. So we'll provide, again, is it modification and restructuring? Is it bringing outside capital in to recapitalize that individual asset? Or is it disposition? So that's probably 75% of our business is to community banks. So, for example, right now, even banks that have acquired failed banks, they'll bring us in on these loss share agreements to help them manage their troubled assets as well.
Okay. Anything to add?
Yes, Mr. Chairman. My name is Matt Norton. I'm with the law firm of Bush, Sipikoff & Shue in Atlanta, and we work with Cantor Fitzgerald and a number of other lenders and sometimes borrowers on troubled assets. I'm primarily here to assist Mr. Kopchak, but one point I would make about this bill as an attorney, speaking just for myself, that I find troubling is if we have a bulk sale of notes and the purchase amount for each note is not separately allocated, which happens quite frequently, you're going to have a situation where the purchaser of the note will basically be forced by the borrower guarantor to not be able to collect on the guarantee, because the purchaser will not be able to tell the court how that debt was separately allocated for each note. And I think that that's going to cause more vagueness in purchase transactions, and it's going to cause purchasers of notes to avoid the state altogether, because of, many note sales occur in bulk, and borrowers have multiple notes frequently, and as do guarantors guarantee multiple notes. If there's no separate allocation, then I would say that the guarantee is not just reduced in collection, but perhaps altogether uncollectible, and I don't think that's what we want to do with this legislation.
Thank you.
I just want to quickly comment real quick. Again, if you cap an investor's ability to collect on to their basis, what's going to happen is they're going to flee this market. They will not buy in the state of Georgia. These banks, you ultimately take away one important exit for them to reduce their exposure to non-performing assets, which provides further pressure, and the regulators are pressuring right now to reduce their non-performing assets. Then again, it creates a competitive disadvantage while banks in other states can sell distressed assets. Their ability to clean up their balance sheet at a much quicker rate puts them in better capital standings. And ultimately, it provides, again, a disadvantage to the Georgia banks, because you're taking away an important exit.
Thank you. Thank you, gentlemen. Thank you for coming. Yeah. Tell him we're still working. Mr. Kevin Ward.
Thank you very much, Mr. Chairman, members of the committee. My name is Kevin Ward, and I represent a number of folks in my practice. I'm a private attorney with Schulten, Ward & Turner. I've had the pleasure of representing a number of developers. I represent some community banks, and I also represent some of the members in the secondary lending institute. I was joking with Mr. Thompson that he and I have recently tried a case with me as his counsel, and I see this from many different perspectives, but I think that I can answer some questions that could not. Is that any better? All right, thank you. Many of the points that I have to make have already been covered very well and eloquently by the community bankers from which some of my clients purchase notes, but I did want to cover in particular a sort of balancing between the benefit and the negatives of this SB 448 and the modifications that have been presented today. This bill will basically it will bail out a few people who have multi-million-dollar loans with typically most of the people that are proposing this change, typically with ventures or with banks, whole bank purchasers where their loans have gotten into the hands of either the secondary market or the whole bank purchasers through the closure of banks and the FDIC taking them over as receivership. I think it's very critical to look at the stages that have occurred to get us to this point. First, at some point, these guarantors went into a bank and said, I promise to pay. I promise to pay 100% of the borrower's debt. That guarantee, as you've heard from a number of the bankers, is a critical element of community banks lending. That promise to pay is also an assignable promise. And that is a critical element of the contract that they entered into willfully and with the help very frequently of counsel at the outset of their relationship with the bank. It is not only assignable, it's transferable, and knowingly at the time that they enter their guarantees, they willingly say that they will pay 100% to successor interests. So in other words, they have at the outset of their guarantees contracted to pay successors in interest. That critical element makes, in my mind, no doubt, leaves no doubt that the bill, as it's proposed, is going to be unconstitutional. And the Georgia Constitution not only looks at retroactivity when you're modifying a note, it's also going to look at how you're affecting contracts that are in existence at the time. There's been a lot of discussion, as is appropriate because of the environment that we're in, with the fact that many failed banks were taken over in receivership by the FDIC. You heard from the banking commissioner that there was something like $80 billion worth of non-accrual assets. A lot of us call it distressed debt, but it's bad loans. You heard that $30 billion of those have occurred quite recently. $14 billion of them are in Georgia. And the majority of those non-accrual assets will, in all likelihood, be handled by one of two folks. It'll either be whole bank purchasers or it'll be the secondary market, to whom these community bankers have said it's so essential to be able to sell their loans. Their ability to sell their loans to the secondary market is often the very last thing that prevents them from going into receivership. And if you take that away, it will undoubtedly accelerate the loss of community banks in the industry. I think what's very important in looking at, there are emotional issues, and first of all, I'd like to say that I think that these hearings are being handled very well, very respectfully to all sides, and I very much appreciate that. When these loans were taken out from the original banks, however, you have to look at the equities. There were significant amounts of money that were taken out by the guarantors, who are frequently the same people that are the principals of the debtors. So in many examples, and I can give particular examples in great number, but in many examples, millions of dollars are taken out by the developers who have come in and promised the banks, look, I know how to do this. I will take the risk. I will pay your interest, but I'll take all the risk. This is a good project. And in return for that, when they take out the loan, they take out millions of dollars. And there are many examples, and that's the norm. That's the incentive for developers to come in and do these deals. They take high risk, they get high returns. That money then goes into the pockets of the developers, and it is now very frequently in the hands of trusts, which as time goes by become less and less available to the community banks, or, in fairness, to the holders of secondary notes. That's because the Uniform Fraudulent Transfer Act has a 4-year statute of limitations. If someone comes in and convinces the legislature to pass a bill that will undoubtedly be challenged and very likely overturned on constitutional grounds, they have bought 2 years of time. During those 2 years of time, the UFTA statute of limitations is running. Many of these banks failed in 2008. So the very practical motivation behind advancing this bill from a private enterprise, from a borrower or a guarantee's point of view, is if I can buy more time and my money has been moved to a trust or my money has been transferred to somebody else, nobody will ever get it. I have personally sat down in a number of meetings where folks have just looked me in the eye and said, we have the money. We're just not going to pay it. And the reason that they're not going to pay it is because it has been put in trust. This bill, I believe, will be found unconstitutional. I know that there are a number of reasons that will occur. I think it'll primarily violate the Georgia Constitution, but it will also face U.S. constitutional challenge. And so if that's the case, why would anybody want it? They would want it because it buys an inordinate amount of time. I do respect that there is a desire to deal with a very difficult situation with more banks that are going to fail. And I even have had discussions with some of the members about the fact that there is what has been called a loophole in the confirmation process, but which is actually not only statutorily correct, but is within the language of most guarantees. Most of the guarantees contain within them a negotiated provision that says the bank may proceed against the guarantor instead of against the collateral. That is a negotiated term which essentially you will change. That is part of the contract that is in the guarantee. And this bill will materially alter that, thus allowing it to be constitutionally challenged even further. So while the intentions are good, and while the citizens of Georgia do need help, this bill is probably not going to get to that point. I personally have recommended that the problem that we have with the confirmation process is that it's winner take all. If you go in and the banks are wrong when they go to confirm a sale, and their appraisal is wrong, or they have somehow not been able to pay the right price, they are completely barred from going after a deficiency. It's a winner take all event. I think you can understand that banks, community banks, large banks, small banks, choose very frequently not to take that risk and to go after the guarantor first, as they have contracted with the guarantors to do. I would like to dispel a very critical myth that I think is weighing heavily on your minds, and that is the issue of sort of a double dipping, that banks or secondary market holders will first go after the guarantors and then go after and collect an additional amount against that debt. That is not what happens, and there are 0% in the clients that I've represented. There is 0 instance in which you get both a judgment and then an additional amount. What you do when you foreclose on property after a guarantee is you apply the appropriate amount to the debt, and a credit is given to the loan. In my personal experience, and certainly with the clients that you all know I represent, the value that has been paid on the foreclosure has been an appraised amount, typically with 10 to 20% added on, and that amount is what's credited to the guarantor's debt after a guarantee. If the legislature were to make the confirmation process less of a winner-take-all, then most of these problems would disappear. Banks may be less frightened about foreclosing on property before they get to the guarantee, and they would most assuredly have a review by the court. The process that's proposed with the newly amended bill creates 3 tiers that you have to go through. Either you foreclose or you don't, you sue on the guarantee, and then afterwards you have to, again, it seems like, go to court and have a review. And that review has to take into account against all banks, against all community banks, and against secondary market holders. They would be required to show the value at the time that they sell it as well. So if the bank, the community bank, or the holder of the note invests $1 million in the property and sell it for $1 million more, your bill would credit the guarantor with that percentage. And that is clearly, respectfully, in my opinion, that is unconstitutional. But it is not the case that in practice there is a double dipping that's going on. The credit is absolutely applied whether the property is foreclosed before or after the guarantees. There is a benefit that occurs that has not been discussed. When these properties are taken over in foreclosure, or if they're going to be taken over, the local taxes are paid by the lender, the community banker, or in the instance of some of my clients, the secondary market holder. In the instance of the Rialto folks, there have been $34 million worth of local taxes paid on properties, whether they were foreclosed on or not. One final point I would like to make with respect to the benefit versus the harm. Everybody sees that a few number of folks will benefit with relief on millions of dollars of their personal debt, the same folks that have looked me in the eye and said, we have the money, but we're not going to pay it. But the ventures that have been created by the FDIC, rightly or wrongly, are significant. There are 31 such ventures. They hold non-performing assets in the amount of $30 billion. You're not dealing with one entity, you're dealing with 31. And the order of the creation of those ventures is critical. They were created after the banks failed, and they were created by open bid. There was no secret deal made with the FDIC. Folks bid on it, on pools of loans, openly and competitively, and the highest bidder won the deal. So I think that it would be a mistake to think that by relieving a few guarantors of several $1 million worth of debt, that you will solve the $30 billion problem that's facing the nation and facing Georgia. And I would recommend against passage of the bill for those reasons. Thank you.
Thank you for coming. Thank you for coming, Mr. Ward. Doug Dillard.
Good afternoon. Thank you, Mr. Chairman, members of the committee.
I'm sorry, Mr. Ward. You've got the final 5 minutes.
I'm going to take less than that, I hope.
Okay. All right.
I hope I'm not the last one. Okay.
No. Well, we're going to be fair to both sides.
I got one sheet.
Okay.
Good afternoon, Mr. Chairman, members of the committee. I'm Doug Dillard. I am currently chairman of the Council for Quality Growth. The council is a trade organization for developers and members of the growth and development industry and those who support and are in the real estate development business. Our membership includes not only developers but also home builders, architects, engineers, gas and electric companies, financial institutions, and community improvement districts. For 27 years, our mission has been to promote balanced and responsible growth throughout the Atlanta region and this great state of Georgia. We have members that are on both sides of this proposed legislation. So the Council of Growth is sort of caught in the middle. And we're not here to take sides this afternoon, but we recognize the need for finding ways to stabilize our economic situation in one of the states hardest hit by this awful real estate depression. And we encourage legislation that would work to serve this purpose and meet the needs of all involved. We continue to be concerned about the constitutionality of this proposal. We also are concerned about the unintended consequences and the effect on the secondary and the credit markets that are so important to the banking industry. The Council, being in a unique position of having members from all parts of the industry, would offer ourselves as a facilitator to help resolve the differences on this bill and to try to work toward satisfactory legislative solution that will serve to jumpstart our economy and work on a long-term solution. The issues raised today are very important. We, as the Council for Quality Growth, want to offer whatever services we have available at our disposal to help resolve any conflict and to provide solutions that will benefit not only the Atlanta region, but all the citizens of this great state. Thank you, sir.
Well, I want to thank the members of the committee, everyone who testified on both sides, and everyone who came to the committee for the order and civility and respect for which we had this very informative hearing. For everyone who signed up to speak both for and against, I don't know when the next meeting will be, what the posture of the committee will be, but we will give you priority in speaking if there is another one, with the exception, unless we're limited to time and the author of the bill wants to come back and use the time that we would allot at the committee. So with that, this meeting's adjourned.